Hello there, and welcome to yet another session of International Law. Today's topic being international claims or state responsibility. So, the doctrine of state responsibility involves the question of the equality of states and the notion that if a state commits an unlawful act against another state, then international responsibility is established between the two, and the injured state then has the right to claim compensation or seek redress against actions taken by the state. State responsibility is also known as international claims, and some examples of these wrongful acts are where a state invades the territory of another state, or the sinking of a state, or even seizing. In continuing with our discussion of state responsibility and the distinction between direct and indirect international wrongs, we also need to look at the relevance of the concept of fault. And this is what will distinguish whether a state, in fact, is responsible or not. So international responsibility has this question of fault, and it's very important because in any case where there's a claim being brought against a state, the defendant state must in fact be proven to somehow directly or indirectly have been at fault and have caused this injury on the innocent state. And therefore, the question of fault is examined by the courts, the International Court of Justice, to see. So having considered this concept of fault, we now move on to discuss direct international wrongs and indirect international wrongs. Firstly, let's look at the direct international wrongs. Where would a state claim against another state on the grounds of a direct international wrong being committed against its sovereignty? Well, a breach of a treaty agreement is considered to be a very serious direct wrong between two states. And if a state has suffered a direct wrong because another state has broken its obligation to that state, then indeed it is a very serious wrong for which a claim can be made for compensation. This was deemed to be so in the case of the Chawsov Factory, a 1920 case. Fault is important, and it is a combination of the element of intention and negligence on the part of the person or the state which have committed the wrong. Intention being dolus and negligence culpa. So these are the two elements which must coincide in order for a state to have been deemed to be at fault. This was brought out in the case of the Home Missionary Society claims, 1920, between Great Britain and the United States of America. So the facts of this case were that a hut tax was levied by the British government to the Sierra Leoneans, and this triggered an uprising which left American missionaries killed and their property damaged. And frequently cited example of the application of this concept of fault, where a direct wrong by one state is committed by another, and the International Court of Justice has the duty to determine whether indeed that state is responsible for the wrong committed, is the case of the Corfu Channel, 1949, held in the International Court of Justice. And in this case, the facts of the case were that there was a consideration as to whether Albania was responsible for the damage caused to two British Navy ships which were blown up due to landmines in the Corfu Channel, which the Albanians had left following the war and had not given due notice that there were these. In the Chawsov Factory case, the Permanent Court of International Justice, which is the predecessor of the International Court of Justice, stated that it was a principle of international law that the breach of an agreement involves an obligation to make reparation, and that reparation was therefore the indispensable complement of a failure to apply a convention. And for this reason, a breach of a treaty agreement is considered to be a fundamental breach of international law, for which the wrongful state automatically owes reparation to the injured state. A second direct international wrong is the failure of a state to respect the territorial rights of other states.